Yes, I understand that. Let's see. If everybody's here, if they would have a seat, and if you would, please cut off your cell phone. I want to welcome y'all to the House Public Safety Committee meeting. We've got several bills on the calendar today. Some we'll be taking action on, some that we won't be taking action on. And I think this may be a proper time. There's an awful lot of emails that went out that were erroneous in nature yesterday on one of the bills. And as I'm reading it, they're giving credit to me, I guess, as the chairman of this committee, asking me to stop giving credence to bills of moms against violence. And I'd like to address this issue now. One of these groups are putting out a lot of misinformation. This bill, when in the legislative process, we hold hearings on bills to see whether they need to be changed, to see what's the validity and whether it's something that would be in the best interest of the people of Georgia. And at any time when groups tell me or they put out information, don't do this and don't do that, they forget what the legislative process is, and that's the process to being heard. Now, some bills that come before us, they're flawed from the start, and those bills very seldom get heard if they are tremendously flawed in their nature. So that being said, the bill in question today is HB 541. This bill is for hearing only today, so that the committee members can get a feel for that. So for those of y'all who are here either for or against that, if it's not in your interest or if you don't feel like listening to any of the presentation on that bill, then I'll just save you time, and you can, if you got other things you'd rather do today. Some of the other bills there will be action taken on them. So at that point, we're going to call up House Bill 968, Representative Jackson.
Thank you, Mr. Chairman and members of the committee. This morning I bring to you House Bill 968, which is a common sense bill. And this bill requires that misdemeanor probation cases be transferred to the county that the person resides in. If you look at on line 14, it says if a defendant is placed on probation in a county of a judicial circuit other than the one in which the defendant resides for committing any misdemeanor offense, such defendant shall have probation supervision transferred to the judicial circuit of the county in which the defendant resides. And that's all we're asking, Mr. Chairman, is that these cases be transferred to the county in which the defendant resides in, because it becomes a hardship to report, and we want these cases transferred to that county in which that defendant resides in.
All right. Any questions from any of the committee members? All right. Yes, sir. Mr. Petrie.
Thank you, Representative Jackson. This seems commonsensical, and so I appreciate you bringing it. So is the department right now, are they kind of burdening people with this kind of issue across county lines, where it's an issue? Help me to understand the problem that exists today and why the department is acting in such a way that would necessitate you doing this.
Well, the problem is right now it says that the current law says that it may, when specifically ordered by the court. And we wanted to the wording to be shall, because a defendant might not even know that he has that right to be transferred to his county that he resides in. And it becomes a hardship to report to another county, especially if you're living in East Central Georgia where I live and you get a ticket up here in Atlanta or somewhere. It becomes a hardship because the family now has to drive him all the way up here. And if there are programs that he has to attend, then he has to come to report to those programs too, which is a hardship when the case can simply be transferred to the county in which he resides in.
Thank you, sir. makes a great deal of sense. Thank you.
Thank you.
Mr. Collins.
My colleague does have a good point. It does seem like a very common sense bill, but a couple of things I just wanted to touch on if I could. In jurisdictions that have multiple probation companies, who's going to decide who gets those cases?
The companies themselves will correspond with each other to decide who get the case.
Okay. And in a lot of misdemeanor cases, it's been my experience in local government, once the fines are paid and the case is dismissed, I mean, some of these are short timers, so to speak.
That's true.
So, I mean, that's another concern that I have with it is you're going to be doing a lot of shuffling around for something that could have been just dealt with there in the jurisdiction where the offense occurred.
Well, I would say if the case is suspended upon payment and the person has the ability to pay, then you don't transfer that case. You let the person just pay the fine or send the money back in to get the fine, and the case is automatically suspended upon payment.
Okay. How about, I'm sorry, Mr. Chairman, I'm just kind
Right
of
ahead.
monopolizing some time here. I apologize. How about your local governments? Has anyone weighed in from the municipal association on this issue, or even the municipal court judges who are having I think they're having a reception across the hall here today?
They have not. I have not heard from any.
Okay. I mean, I just think there are a lot of moving pieces here, and I certainly hope this committee will continue to vet this bill, because I think there's some unintended consequences that could be seen down the road, Mr. Chairman.
Mr. Glanton.
Thank you, Mr. Chairman. Representative Jackson, could you give us a breakdown on the fines and fees, how there's separated from the county that issued the citation versus the county that the individual reside in?
Well, as you know, the fines also provide for a probation fee to be paid. The probation fee would be paid to the supervising county, wherever that person is being supervised, but the fines would be paid in the circuit that person was sentenced in, or in the county that person was sentenced in. There's a way it would be broken down.
And follow up, Mr. Chairman?
Yes, sir.
And also, what has been your experience in regards to, and you had, 25, 30 years as a probation officer? Or
18.
18 years? Okay, I was giving you a little more pension, but that's okay.
Well, it was actually 34 years with the state, with just 18 with probation.
Okay, so my point is, you know what you're talking about.
Mm-hmm.
And so, what has been your history, what has been your understanding of the folk that this fall under, where they can't get to another location? If someone gets a citation in Rome, Georgia, my hometown, and they live in Sandersville, what's been your experience? The population of people, is it poor people that can't afford to move from one location to another? What's been your experience?
My experience has been it places a hardship on people that don't have the money to pay to get the fine cases suspended in court, or a couple of weeks after they come to court. It places a hardship because these people have jobs in the county they reside in. If they have to report, whether it's to report or whether it's to attend a program, then they have to get somebody to drive them all the way up here. Say you got a suspended license case, that person automatically can't drive anymore. Well, that puts a hardship on either a parent or a grandparent or somebody in the family to have to transport them to the program. And then they've got to wait until a couple of hours until they attend the program and whatnot. So that puts a hardship on family members because of these cases having to have not been transferred to the residing county that person lives in.
Another follow-up, Mr. Chairman.
Yes, sir.
And regardless of whether their request is to be able to transfer the case or not, the court that administered the fines or fees or probation or whatever we're talking about, they still have discretion and they still have oversight. Is that correct?
That's correct.
All right. Ms. Frazier.
Yes, sir. Thank you, Mr. Chairman. Representative Jackson, isn't it true that a lot of our constituents that incur citations or fines, they're from all over the state, and that And that's just not confined to the Atlanta area. So we are rural Georgia. So if we get a ticket up here and we live in Augusta, I have to drive back up here to get all of that resolved. Isn't that what this bill does, is just make it a little bit more convenient for me to take care of my business in Augusta, but the fines will still be here in Atlanta. But we have to look at the whole state, not just the Atlanta area. But people are traveling from all over the state. So this will make it better for all of us if we're able to deal with these problems in our local districts.
Thank you, Representative Frazier. That's true.
Did it, Ms. Frazier?
Mr. Chairman, at the appropriate time, I'd like to make a motion.
Well, at the appropriate time,
At the
you will be
appropriate
able
time,
to.
sir.
We've got some, open up for testimony then.
Okay.
Any further questions of the committee members? Does anyone wish to be heard on this bill? Yes, sir. If you would come up and identify yourself, please.
Mr. Chairman, I apologize, I did not sign up in advance. I just saw this bill, and I have not had a chance to talk to the author. My name is Steve Goss. I'm Superior Court Judge from Albany, and I am the chairman of the Council of Accountability Court Judges of Georgia. The only concern that I would like to voice and like the committee to consider is you take a situation like myself. I'm a Superior Court judge. I'm in a circuit that has an active state court, so I hear very few misdemeanors, typically. Only if, say, for example, the district attorney decides to plead a felony down to a misdemeanor. And so my interaction, like many Superior Court judges, is fairly limited in sentencing people to straight probation on a misdemeanor. However, the concern I have is that this mandates that, you know, it says shall transfer to the county of residence. We have situations many times in accountability courts where a person comes in and, say, a drug court, and the prosecutor says, we want this person in drug court, we've staffed it, the defense attorney wants it, the participant wants it, the DA wants it, the judge agrees, and they plead it down to 2 misdemeanors, and we run them consecutive 12 and 12, so we have 24 months, long enough to get somebody through the drug court program. But many times, say in Albany, for example, they live in Worth County, but they committed the offense in Albany and Dougherty County, which were adjacent counties, but we would have to move the probation out of county, which makes it more difficult to work with them in the drug court program, where we have a representative from that local probation office participating and giving feedback to the judge. So I would ask that the committee consider making an exception if a person is enrolled in an accountability court program in the sentencing county. That would give us the flexibility to continue to have that dialogue with the probation officer to see how the person's doing on probation. That would be my only concern.
Any questions for the judge from any of the committee members? Representative Jackson.
Thank you, Mr. Chairman. I want to thank the judge for coming and offering that suggestion too, and I'd be very agreeable to that.
Yes, sir. And again, I'm sorry I haven't spoken to you earlier. I didn't see it until just a few minutes ago, so I regret it. Did not have a chance to talk to you in advance.
Thank you, sir.
Thank you, Mr. Chairman.
Thank you, Judge. If you would, we might get you to work with counsel and Representative Jackson over here in just a second for some possible changes in this. Is there anyone else who wishes to be heard? Yes, sir. Come forward.
Good morning, Mr. Chairman and members of this committee. My name is Sir Major Page. I am the president of Black Lives Matter Greater Atlanta. And what I wanted to say in response to this legislation is I too support this initiative. Thank you, Representative Jackson. The reason why we support this bill is because it's no secret that there's a lot of folks that I represent end up on probation, sometimes by design. If this legislation allows us or my folks that I represent to take care of our legal business without hindering a burden to other family members, why not do it? And so we're in support of this. I thank you so much, and our community thanks you, Representative Jackson. Thank you.
Thank you, sir. Anyone else that wishes to be heard? All right. If I might ask Representative Jackson, could you and the judge maybe work with Julius over there? And while we move on to the next bill, y'all might can get some amended language, and we'll suspend action on 968. Representative Cannon here. House Bill 953.
Well, good morning, members of the committee. Thank you, Mr. Chair. I'm presenting you with House Bill 953. The LC number is 391849. This morning, I'm presenting this bill that makes a minute change to the way that the uniform traffic citation is recorded in Georgia. This bill basically adds a space for a bicycle on a uniform traffic citation. If it's pleasing to the chair, I have some copies of the traffic citations to hand to the committee.
Be fine.
Thank you. So at present, if there is an incident involving a bicycle where a police officer will issue a ticket, there's no way for the court to officially note that the vehicle was involved in an incident with a bicycle. It's done informally and without uniformity in our state. I've heard in Athens, where the cycling community is very large, officers write the make and model of the bike in the make and model category, and then write bike in large letters across the ticket. This is what you will see handed out to you. So then the clerk can, in their office, kind of put it in a separate area and deal with it later. But this is not a uniform way to deal with these cases properly. So this minute change at the bottom of House Bill 953 simply says that the uniform traffic citation shall include a method for notating that a violation was committed by either the operator of a vehicle or a bicycle. If it's pleasing to the committee, I can tell you about the types of incidents that happen on bicycles. And the real issue here is that we want to collect some better data. So other states are able to collect data on what happens when bicycles run stop signs or red lights, or when they split lanes at intersections, or the different moving violations such as riding against traffic, or actually riding on sidewalks. In the state of Georgia, if you are over 12 years old, it's not legal for you to ride on a sidewalk. So I would, like to really thank some of the individuals who have helped me and organizations as I've put together this legislation. Major John Quigley with the Special Projects Division of Atlanta Police Department. Becky Katz from the City of Atlanta, she's our Chief Bicycle Officer. The associations of police chiefs and the Sheriff Association, Georgia Bikes, Athens Bikes, Atlanta Bicycle Coalition. And if it is pleasing to the chair at this time, I would love to speak about some of the changes that I think could be helpful to this legislation.
Yes, ma'am. Go right ahead.
So looking at the line 21, we see that it's cited as 2019. That would say to our departments, go ahead and get some new tickets now. And that is not what we want to do. We want to give y'all some time to be able to make these changes, to get new ones printed out. So we want to change that to 2020 as per the recommendation of, I believe it was Mr. Rotundo or Mr. Norris. Additionally, if some of those departments are not able to go ahead and get it by 2020, we just want to say, or until you've expended all of the ones that you have printed out. And that's all.
Mr. Glenn.
Actually, Mr. Chairman, she just addressed both of my concerns.
Any other questions from any of the committee members? Is there anyone else here is there anyone that wishes to be heard on this matter? Yes, ma'am. Come forward.
Hello, Chairman Powell and members of the committee. Thank you for the opportunity to come and speak with you this morning. Thanks and gratitude is extended to Representative Parks for writing Bill H.R. 953. My name is Nedra Deadweiler. I work with Georgia Bikes. We're a statewide bike advocacy organization. I'm an educator, and my job is to travel around the state and talk to law enforcement, communities around bicycle safety. This bill will allowing a uniform traffic citation and complaint form will allow us to capture data on bicycling specifically. This will help us to not only improve the roadways and safety for every person on the road, including cars, but allow us to improve the ways that we educate motorists, the way that we educate bicyclists, and also just communities in general. We'll know how and why people are being hurt. Currently, right now, with the traffic citation, we only really know if someone is killed, if it's a fatal crash. And it's important to prevent that. Our goal is to not just decrease, but to, have zero deaths, zero fatalities. And I work in partnership with GOHS, the Governor's Office of Highway Safety, and that's our bottom line. So this will just to help us to educate better, to have more information, diverse, from Waycross. I mean, I've gone to Waycross. I spent a lot of time in Savannah, Augusta, Rome. Like, I'm all over the place. And the riders are from folks with no money, no other means of travel except by walking or on bike, to, up in Roswell, where it's like, people are affluent and it's recreational. So to cover the full gamut, this will just help us to be able to track that information specifically. So thank you.
Any questions? Do we have any questions? All right. Ms. Cannon. Is there anyone else who wishes to be heard on this bill? Ms. Cannon, have you had a chance to talk to the Department of Driver Services?
Not yet.
Let's see, number 16. Who would that be?
Mr. Chairman, that's me, but Representative Taylor has one.
Thank you.
Right.
I had a quick question, and this is for bikes, and thank you for bringing it. It's very important. I'm in a rural area, and now even some of our larger areas have utility vehicles and things like that, four-wheelers. Do we need to identify different types of vehicles other than bikes, or? It just dawned on me that though we have lots of bicyclers too, we also have other types of vehicles.
I would agree.
All right, thank you. I like it, it's good, so I'm not complaining, just thinking for the future. Thank you.
I think that the last time the UTC was updated was a number of years ago.
Yeah.
Any other questions from any of the committee members? I do have a concern on the date of January the 1st, 2019. Without having talked to DDS or any of the other jurisdictional agencies, I don't know how many of these, the DDS 32s, are already pre-printed. I have a strange feeling it could be virtually warehouses full of these. We don't want them to have to throw those out.
Exactly.
To do this.
And so
All right. Mr. Glanton.
Thank you, Mr. Chairman, and I too share your concern. I would suggest that we do an amendment that would take it out to 2020 and insert, and Julius, you help me out here, insert after 2020 or until current forms are exhausted, whichever comes first. Something of that nature.
Very good. Mr. Collins.
If I may contribute here, I know a lot of departments are going to electronic tickets.
Yeah.
So, that needs to be taken into consideration. I think now you could probably just, update that software fairly easy and not miss an opportunity to help representatives start collecting some of that data. So just keep that in mind.
Yes, that has been a consideration, that there are officers who are able to type it in and print it right out. So we are inclusive of that. If there is an amendment, I'm willing to accept it.
All right. Ms. Taylor or
That's me,
Mr.
Mr.
Gravely?
Chairman. Can
Mr.
that-
Gravely.
To the author of the bill, thank you, Mr. Chairman. Can that be, for, Julius, help us out on that amendment, obviously, but can we could immediately start capturing that, to Representative Collins's point, for those jurisdictions and departments that have that capability. I'd want to make sure that we didn't push it out too far when the capability for immediate collection of that particular data or upgrade of the UTC could be done in those departments that use electronic manners.
Thank you.
I don't know if Mr. Rotundo or what wants to comment on that.
Sir, without direct knowledge on this, I think the format that's printed out on the UTCs is the standard governmental format, so we have to change the format and have them change the software. My thought process, and I see Representative Hitchens shaking his head. To the amendment, I suggested the 2020 date because we've already encountered this issue before with local law enforcement people when they purchase traffic citations, purchase them in bulk to get the best price, particularly in smaller units. So they tend to have an excessive amount. More than that, it comes down to the budget cycles that each department uses. Some budget cycle starts July 1st, so that's probably already in the works. They could even consider 2018, some in October. Again, they could consider 19 rather. They could consider 19 again. So 2020, if you're going forward with the bill, appears to be the right time. The other concern that has been brought to my attention many times before, whenever there's a change, is the printers can't even make these tickets quick enough because they make them in bulk. You go to your individual printer, it goes to the UTCs, and basically it takes a while for them to print it. So if this bill does pass, I certainly encourage the 2020 date as being the sole date.
All right. Thank you, Frank. If I might make a suggestion, why don't, Ms. Cannon, why don't you work with Mr. Glanton and Mr. Gravely? Let them, y'all contact DDS, contact the State Patrol. You have the Chiefs Association here and the Sheriff's Association to get their thoughts about a date and about how this would go forward, given that we have the electronic filings, and that way we can move forward at that time.
Thank you.
Yes. Thank you, ma'am.
You're welcome.
All right. Chairman Nimmer.
Thank you, Mr. Chairman and members of the committee, for the opportunity to come before you this morning. The measure I bring to you for your consideration is a familiar measure. Chairman Powell, you actually carried this bill in the form of House Bill 458. There's a version of this bill traveling through the Senate, carried by Senator Beach, known as SB 435. This is the bill that we took up as a House body last year and passed out of our chamber. Y'all passed it out of this committee overwhelmingly, dealing with the opportunity to give camera technology in school zones. It is not a mandate on local government. It is a passive measure by the state to give local control to utilize this if deemed necessary. Mr. Chairman, y'all are very familiar with this measure. I'm going to leave my remarks at there unless y'all have any questions.
All right. Questions? Mr. Glanton? No? Any questions from any of the committee members? Y'all may remember this bill from last year. Ms. Frazier?
I'm not very familiar with it, so I just need a little bit more details about it.
Okay,
Chairman Nimmer.
Yes, ma'am, Representative. Mr. Chairman, may I continue?
You certainly may.
All right, this is House Bill 978, LC 411457 that I'm working off of that you would see in front of you. I'm sure there's a copy provided. This tweaks a little bit of the language, Representative Frazier, dealing with the camera technology on school buses that this body passed in 2011. It just changes, it lowers and caps the fines so they don't start at a $300 and graduate up. It caps them at $250. It also says that a passerby coming on a divided highway cannot be issued a citation for passing that school bus when seen on camera, which is current law. Down in the main meat of the bill, that gives the local governments the options to enter a contract or install themselves for technology dealing with surveillance in the school zone is the main meat of the bill. You'll see some definitions given in there just for clarity and consistency throughout the bill to know what we're talking about in the reference of agent and owner and recorded images and video recording devices. That is in the first portion of the bill. The bill goes on to talk about how this contractual agreement would be made between the local governing body and a third-party agent to install and monitor the surveillance equipment. I want to make note right there that that third-party agent cannot issue a citation. That citation has to be sent back to a local law enforcement. They have to review it and then send it out from there. One minor change, Mr. Chairman, and I'm sorry I did not point this out. I believe this is a change from your version last year. If the civilian does not pay the fine when issued a fine in the amount of time that's been given, a notice will be sent to Department of Revenue, and when that individual goes to renew their tag, that tag will be put on hold. This is for civil penalty only, no points on their license, no criminal intent. Again, this is passive, this is not a mandate, this gives local control for people that think in their area this is a good measure. We've had several deaths and major injuries in the state of Georgia already in these school zones, and this is just a measure for school boards and local governments to come together, and if they think surveillance technology is the right thing to keep their children, their meemaws and peepaws and their mamas and daddies, and the crosswalk tenants safe, then they can install this if they deem necessary.
All right. Any other questions from any of the committee members? Is there anyone here this morning that wishes to be heard on this bill? Mr. Bob Dallas.
Thank you, Mr. Chairman, members of the committee. My name is Bob Dallas. I was the director of the Governor's Office of Highway Safety from 2003 to 2011. I'm also immediate past chair of PEDS, a pedestrian advocacy group in the state. This bill will save lives. We have read a lot about the deaths in our crosswalks. There are many, many that you haven't read about because they're just serious injuries. I know by having this, it'll encourage significant slowing down in our crosswalk areas and make it safe, encourage more people to walk, do all the kinds of things that we want near a school. I think it's a positive bill, one of the best ones I've seen in a long time, addressing the issue of excessive speed in our school zones. I'm glad to answer any questions with respect to this.
Any questions from any of the committee members, Mr. Dallas? Good to have you here.
Thank you, sir.
All right. Anyone else? Is there anyone else in attendance who wishes to be heard on this bill? If not, what's the pleasure of the committee? We have a due pass. We have a second. All right. Any further questions? Any subsequent motions? If not, all in favor say aye. Aye. Opposed? The ayes have it.
Thank you, Mr. Chairman and members of the committee.
Good bill.
Yes, sir. Had a good leader on this one.
Is Representative Lott here? House Bill 992.
Thank you, Mr. Chairman, members of the committee. I am here with House Bill 992, LC 337370. This bill here is a cleanup bill with some code changes here for initiated by the Department of Public Health and the Georgia Association of Emergency Medical Services. The bill addresses a section of code relating to external defibrillators, the AEDs, and the outdated terminology and regulations of something called base stations. There's no new language in this bill, It is all line out items here. We're removing code. If you basically look page to page, that's it. There's no new wording. And I'll answer any questions if need be, but the basis for this was when artificial external defibrillators were initiated into practice for medical purposes, we were a little more strict on some of the guidelines. So there's regulations in here that stated certain educational requirements and checkups. Well, now AEDs are everywhere and for everyone. So a lot of that language is just not useful. There's something on here called base stations. They've actually never existed in Georgia, so we've removed that as well. If you have any questions, I'd be willing to answer. There is someone here from Ms. Cobb.
Any questions from any of the
Public
committee
Health
members
is
of the
here.
author? Mr. Beach.
I just have a comment to my friend, Representative. If we updated every bill like you have here, Julius would need half the books he's got in his office. Looks like you've just really cut this one on down to size, so thank you.
Well, thank you. Our Public Health Department is working for us.
Any other questions from any of the committee members? Is there anyone here in attendance that wishes to be heard on this matter? Pretty good bill. If not, what's the will of the committee? We have a motion. Do we have a second? Further discussion, further motions? If not, all in favor say aye. Aye. Opposed? And ayes have it.
Thank you, committee.
See you in the rules. All right. Representative Jackson. We're going to move back to House Bill 968. Is there anyone else? There's been a little bit of work done, but is there anyone else that wishes to speak on this? I understand we got somebody from the municipal court judges here that might want to say a word. Good deal. Mr. Samuels, so good to see you.
Good morning. Good to see you.
Small world, isn't it?
Indeed. I was here to provide breakfast for you today, and here I am before the committee. Good morning. My name is Bubba Samuels. I'm the municipal court judge in the city of Monroe and in Franklin Springs. So I've just read this bill for the first time, and I have Rashida Oliver here as well. I am the vice president of the Council of Municipal Court Judges, but I'm not speaking on behalf of the council. I'm speaking only on my own behalf as a municipal court judge. And I would just caution the committee with regard to maybe some of the logistics that we would have to deal with if the bill is passed as written. Specifically, I face it in my court regularly that a defendant will actually be on probation in another jurisdiction, perhaps in another county, another municipality. As you know, municipal courts have varying arrangements with probation companies. Some of them are private probation companies. Some of them are government run, where the probation folks are county employees. And in the absence of a relationship with those providers, I would think the providers might have some logistics issues with doing what is ordered in the order of probation, not just in the transfer of funds from that they collect from the probationer to the cities or the courts, but in the actual observation and completion of probation conditions, such as community service or whatever those conditions may be. Logistically, I believe it would be difficult for the court to monitor the successful completion of the probation conditions that I order as a condition of their circumstances. I certainly understand that for convenience sake, a defendant who is ordered on probation would benefit from performing their conditions close to home. But I think in order to accomplish that, we've got to consider the circumstances of who would be supervising and what their relationship would be back to the court, because the court has an interest in seeing that those probation conditions are satisfied. So I think I certainly don't disagree with the concept conceptually, but I would ask the committee to consider some of those logistics issues and in developing it further.
Do we have any questions from any of the committee members? Thanks, Bubba.
Thank you for your time.
Good to see you.
Good to see you.
All righty. Representative Jackson, if you might go back to the podium, or you can sit there at the desk if you wish, and tell us what changes that you and the Superior Court judge could come up with.
Thank you, Mr. Chairman, members of the committee. There's an amendment been offered up, and if Julius would read the amendment.
What we'll do is on line 17, after reside, we'll insert this clause. Provided, however, that if the defendant is enrolled and participating in a program under a drug court division, mental health court division, veterans court division, or operating under the influence court division in the county of the sentencing court as provided for in Chapter 1 of Title 15, then such probation supervision shall be at the discretion of the court.
All right. Did all the members understand that very clear? Any questions from any of the committee members? Number 11 down there. Yes, sir.
Thank you, Mr. Chairman. Representative Jackson, thank you for trying to address this, and I get exactly where your intent is. But even with the amendment, if we just left it exactly the way it is now, couldn't the court then do that?
I believe they could.
So we wouldn't have to go through the process of the amendment or even the bill.
Well,
if we just left it, correct? Or
if you read
something?
starting on line 14 and go down to line 16, it says shall, where previous legislation said may, and these people are being left out.
Right, and that's kind of what I'm suggesting, though, because if we're going to then tack on through an amendment that some carve-outs here, if we just left it at may, the way it currently is in code, then that addresses these issues, does it not? I mean, because the court still could then transfer the supervision to another county.
If we left it like it is, we could, the same problems that we've got now would still be there.
Any other questions from any of the committee members? Do we have anyone else that wants to be heard on this, since there's been a proposed amendment? Ms. Nish, Deborah?
Good morning, Mr. Chairman and member of the committees, and Representative Jackson, I'm sorry I haven't had an opportunity to talk to you this morning. There was quite a bit of traffic around the Capitol. I know a little bit about this, probably just enough to be dangerous. But as the judge stated, it would be a logistical nightmare to try to do this if you did it for every single case. The people who regulate misdemeanor probation services are over at the Department of Community Supervision, and they have in their rules and regs a process in which to do this, to transfer somebody back to the county of their residence. So there is a process in place. Right now, the way that misdemeanor probation typically works is the offender goes into the probation officer, and the probation officer is actually collecting the fine money that is owed to the jurisdiction, along with any supervision fees, and sending that to the clerk of court for the county or the jurisdiction that the ticket was written. And so I think that would be a terrible nightmare to try to figure out where that fine money goes and how much, and to track the money and to make sure it's going right back to the right jurisdiction. And then there's always, the situation if they have to revoke the probation, then which jurisdiction do they go back to jail in under the revocation? So, I understand what you're trying to do, but I do think that there's a process in place, and that if you work through the misdemeanor probation division over at the Department of Community Supervision, they could maybe even put some rules in place to make sure that if somebody wanted to go back to the county of their residence, there would be a way for them to make that request.
You do have some questions, Mr. Glanton.
Thank you, Mr. Chairman. I'm a little bit confused here because, and that's not unusual, but certainly, certainly, I'm understanding this to believe that it's already in law, that it's already the ability to transfer a probation from one jurisdiction to another is already law. The only thing that I see that this bill speaks to is whether they may or shall.
You are correct.
So help me understand why we're talking about logistics that already exist in the existing statute.
Well, I could give you a good example. Okay, if you're in the metro area and you get a ticket in the city of Atlanta and you live in DeKalb, there's really not much of a reason to transfer your probation because you're right there together. And again, it gets back to the collection of the fine money and where do those funds go, and how do you keep account of that fine money between those jurisdictions. Whoever writes the ticket or wherever the offense occurs, the sentencing court imposes those conditions, the fines, the conditions of probation, in order to make sure, and the probation companies are typically collecting that money on behalf of the court and turning that over to the clerk of court every month. And so that just sets up a whole nother structure that the jurisdictions have to then try to follow that money and make sure that they're being accountable and that they're collecting everything they're supposed to get.
Follow up, Mr. Chairman.
Follow up.
I'm still at a place where I don't understand that we're not talking about new policies, new procedures. We're talking about policies and procedures that already exist, that already allows for a probationer to move from one jurisdiction to another. So in my mind, there is no additional logistical requirements that are outside the scope of the statute. The only thing we're talking about here is whether it should be mandated or not.
Correct.
But the procedures are already in place. Am I not wrong?
They are, but it's up to the sentencing court. It's at the discretion of the judge, to decide whether or not that is necessary for that person to go back to their county of residence.
If I'm not mistaken, I think that the language in the amendment addresses the discretion of the court. Am I
Well,
correct?
if they're in an accountability court, but we're talking about more than just offenders in an accountability court. And that discretion is there now. And there are, like I said, there are procedures in place under the rules and regs under which the misdemeanor probation entities operate.
So would you say that the process for transferring, the logistical process for transferring already exists?
Yes, sir, it does.
So there would be no added burden on the court system to implement a new procedure for transferring probationers from one district to
There
another?
would be a lot of additional work if every case was required to go back to the county of residence.
So the issue is the amount of cases that would be absorbed based on the mandate versus the discretion, true discretion of the
Correct.
courts to make a determination.
That is correct.
Mr. Collins.
And you probably know more about this than I do. But
I wouldn't count on it, but I'll try.
What about the the legal issues that you have with each court having a contract with a private probation company, and that private probation company is covered under, with their professional insurance. They're hooked to that court, and that court's hooked to them.
You're correct. That's
So-
another issue.
So the other issue there is the legal can of worms we're opening up if one court is having to supervise probation for a municipality where they don't have a contractual agreement.
Correct.
I mean, does that not open up another
It
issue?
does open up another can of worms, and it becomes even more complicated when you move into the municipal court arena, because, we have county courts that are putting people on probation. There may be a county probation department, or they could contract with somebody. But then you're going between these private, public, trying to, and I'm afraid that these probationers would fall through the cracks is what would happen.
Follow up, Mr. Chairman, if I may, and that's just may a point of personal privilege here. I commend my colleague for what he's doing. He worked in the trenches in this realm, and he knows a lot more about it than I do. But I will say this, over the last few years, I think this state has seen a fundamental shift in how we treat those who are on probation or parole with criminal justice reform. And I think that my colleague may say that he's seen that as well. And the change that needs to happen, and the change that is happening, the statistics that I've seen with people on private probation rank Georgia #1, and that is a crime within itself. So I want to say again, it's not the issue that I have with what he's trying to do, it's just the process in which we're doing it.
Those are my feelings exactly. I understand why he's trying to do that, but I do think we have procedures in place, and there could be a rule change again to the people who oversee private probation or misdemeanor probation to make sure that offenders are given that opportunity and know that they have the opportunity to transfer.
Right. Mr. Gravely.
To my colleague's point, I think when you were saying it's already current law, correct? What is current law is the mechanism for the transfer, correct?
Well, it's under rule and reg. I don't think it's written into the statute. It's under rule and reg. Right now, current law is that the judge has the discretion. The sentencing court has the discretion.
That is correct. Lines 15 and 16 of the bill, in which such defendant resides for committing any misdemeanor offense. Such defendant may, when specifically ordered by the court. So the court recognizes the logistical problems that you are stating here at the podium, which is why, but it's not mandated. So the court is not ordering that they are allowed to do that, correct?
Some are.
Some are when it makes
but apparently,
sense.
you've obviously got a situation. I didn't hear the beginning of your testimony. So obviously there's a situation in your jurisdiction. But they do it across the state now, and they do it between accountability courts too. There are transfers that take place within accountability courts, and there are procedures there. But it is all at the discretion of the sentencing court.
So the sentencing court in certain situations may realize that the logistics are going to be a little bit too high of a bar to accomplish without some type of confusion.
And it could be that the sentencing court is not saying to those probationers, you have this opportunity, and that may be where a rule change may be appropriate in the oversight of misdemeanor probation, so that they make the probationers aware that they can apply to be transferred to another jurisdiction.
Thank you.
In lieu of just saying everybody shall be transferred, because there are so many different misdemeanor probation systems. The state gave it back to us. They used to supervise misdemeanor offenses, and they gave it back to the locals. And so now we've got a hodgepodge of different probation systems, and it would be very difficult to keep up with those offenders and with the fine money and with the fees and making sure that they met the conditions of their probation.
Representative Jackson.
Thank you, Mr. Chairman. The bill itself, when you talk about logistics as far as the fines and the fees, we're not trying to separate the fines from the sentencing court. We want the fines to be paid at the sentencing court, the place that they're sentenced in. The probation fee might be paid at the county probation officer that they are transferred to, but the fines are already being collected by the sentencing court. And we wouldn't want that to change in this bill. This bill doesn't address any changes in the fines and the fees.
Well, typically
We-
the probation supervision, whoever's providing probation supervision is collecting that fine
That
money
fine.
every month.
Mhm.
And so, again, that gets back to a bookkeeping nightmare, keeping up with which defendants were transferred back to their home county, and are we getting the fine money? Because the sentencing court may not have a relationship with the probation provider in the jurisdiction that they transfer to. In other words, like you said, there is no contract, there is no agreement, there is no requirement that that probation provider remit to that sentencing court because they don't have a relationship with them.
Well, it's been further inquiry. It's been my experience as a probation officer that when a person doesn't pay, then that's when a warrant is issued. That's when you bring that person back to court. That person's responsibility is to pay their fines. Good supervision is required on probationers, whether it's with state probation or whether it's with private
Well, you
probation.
are exactly
and when,
correct.
and when you monitoring cases, you make sure that the fines are being paid under good supervision. And all we're trying to do is make sure these people have a fair chance to report. Because without the transference, these people can be locked up for failure to report, for failure to do the programs or participate in the programs when they don't have the ability to drive back from South Georgia back to Atlanta or to North Georgia. And it could be a case where a person simply had his license suspended for child support. And a lot of times, people don't even know their license have been suspended, and they get caught in a traffic stop, and they've got a suspended license case. Well, that suspended license is $500 or more. That person has to report back to his probation officer. When it puts a hardship on the families, the whole family is under hardship because of that case not being transferred.
I understand. But, you know, there have been a lot of changes made to misdemeanor probation. I mean, we have pay-only probation now for those lesser offenses. I mean, there have been a lot of changes through criminal justice reform.
So the logistics have been worked out.
Well, I mean, they have the ability, if they're in South Georgia and they get a ticket in North Georgia, the sentencing court's going to consider that and transfer them. But if they are in Dunwoody and they get a ticket in the city of Atlanta, then there's really no need. I mean, there is no need for a requirement that they be transferred to a different jurisdiction, which gets back to the discretion of the sentencing court.
That's understandable. Thank you.
Mr.
All right.
Petrie.
Thank you. And I have a question for my good friend, Representative Jackson, this issue you've raised is a good one that we need to correct, but I'm also listening here to several issues of real concern. So I have what might be a compromise that I want to just throw out there, which would be we're trying to make sure that we don't have an undue burden on people, which we want to clear up. But your example of a Fulton and a DeKalb County, adjacent counties, is as commonsensical as what Representative Jackson's trying to do. So what if there was some distance requirements in here, or what if this was a shall when it was in non-adjacent counties, or what if it was a shall when it was more than X number of miles, rather than always a shall? But we undid what we do today, which was leave it completely under, a may scenario. So what are both of your thoughts about trying to circumscribe it with some kind of distance?
I mean, I understand what Representative is trying to do, and we would be more than happy to sit down and work with you and try to figure out a way to address your problem short of the shall. And I think that it is very complicated because of the contracts and because of the jurisdictional issues. And I think it would be helpful to get the Department of Community Supervision involved, because they're the ones that oversee the misdemeanor probation providers, to make sure that we are really addressing your problem in the least impactful way that we can to the court operation.
All right. Mr. Lanton.
Thank you, Mr. Chairman. I guess regarding the scope of this, I'm trying to wrap myself around, are we talking about, I think the fear is that there's going to be an abundance of folk that are requesting these transfers.
There would be.
Can you give me some idea of the scope, and if it was something that the individual had to request rather than making it a mandate of the court to do automatically? What's your thoughts on that?
I would much prefer to see a request. I think that's a reasonable, that there be, that it gets back to the rulemaking and what the providers are required to do. Perhaps they let them know that they can transfer if they find out that they don't live in that jurisdiction, and then go through the proper channels to do that. Because when you're talking about everybody who gets a misdemeanor offense, which are traffic tickets, a lot of them, who cannot pay, goes under supervision until they pay. I mean, it's hundreds of thousands of cases, potentially, if you're talking about transferring, across Fulton into cab lines. So, again, I think that there could be something put in place for those where it is a real problem, where they are having to go 3 or 4 counties over or a good distance to be able to make the request to have their case transferred, as opposed to the shall.
One last follow-up, Mr. Chairman.
Yes, sir.
Can you give me some idea of the raw percentage of folk that are now requesting transfers? Because I think we're thinking about an abundance of folks doing this. So where are we now?
I don't have that information. I'm sorry. The Department of Community Supervision may. I don't know if they're here, but I have no idea because I'm not working with the sentencing courts. But I do know that there's a process in place because I worked on the committee that put it in place. So I know that there is a process in place, but I don't really know how many. Some of the judges here could tell you better than I could how many they have that are not people within their jurisdiction that might be eligible for transfer. And I think there's some providers here that can answer some of these questions better than I can.
I guess I'm just curious because we're using hypotheticals to say that if this bill is in fact enacted, that we're going to have an abundance of requests for transfer. But I'd like to know what that number is now that justifies us believing that there would be an abundance of transfer requests.
Yeah, and I don't have that number. I'm sorry, but the shall would require everybody to be transferred that wasn't in that jurisdiction.
All right. Any other questions? Any further questions? Last chance. Anyone else wish to be heard? Thank you, Ms. Niss. Now, for those of y'all who don't know Deborah, she's a little bit shy about her credentials. She only worked for AOC for a long time. And so she has a certain level of knowledge. Yes, ma'am.
Good morning. My name is Rashida Oliver. I am a municipal court judge in the city of East Point. In no way speaking on behalf of the council, though I am a past president. My concern as it pertains to try and answer your question, when you're in a jurisdiction where almost everybody that comes through your jurisdiction is not from that jurisdiction, if I had to send them where they were, which there's not a problem if there's someone there to receive them, is there a mandate that will be on the probation companies that are outside of the ones we contract with that's going to mandate that they take them, and whose responsibility is it going to be to make sure that there's somewhere to actually send them? So those are concerns from a municipality standpoint that just leap out. We do have people from out of state that we allow them to do pay online or to report online, to do community service outside of the jurisdiction, but they're being still monitored by the probation company that we actually have a contract with. So I have people who say, I don't live in this area, can I do it here? But there's no contract with some other company that I can actually send them to say, okay, but report there instead of report here. So we do phone reports, we do mail reports. We do try to get around that. So it's very different from what you deal with in the county, where you have county programs that actually may have agreements to go back and forth and to transfer. But it's very different from municipalities. So I would say out of 200 cases that I may see a day, 80% of those people may be outside of our jurisdiction because we're right near the airport. And so we take account for that when we place people on probation if we have to. Where they're going to do their community service, if it's a DUI, where they can go for classes, and we try to take account for that. But it's very difficult to say because everyone doesn't ask for it, because we have other options for some of them. but it would be logistically, from my standpoint, has nothing to do with the money. I know that's some things that people track, but it's more about how are we going to do this? How are we going to send it? Where are we going to send it? And if I send it, are they required to take it? I'm very comfortable with the contract and the company that I'm using now, but I may not be comfortable with the contract that's in that other jurisdiction. They may not have the same level of supervision. They should, but they may not be as responsible to the supervision that my court would require on a particular situation. And then those things, once transferred, if they violate, they have to be transferred back generally for you to then do a warrant. So what's the tolling process on that? Are they going to toll it in one jurisdiction so that the time doesn't run out on the probation? What's the length of time? So it's a lot of questions that go into how you put this and implement it. And those are the concerns that I, as a municipal court judge, would have. Aside from tracking and tracing funds, because we have ACH and other things now, so you can track and trace, it would make it more difficult for both jurisdictions. But more importantly, is there a mandate that's going to require someone to take who you're sending? So those would be some of the concerns that I would have. But to answer your question, there would be quite a few who would be eligible for a transfer. The question is, are they going to ask for one knowing that they have other options?
Representative Jackson.
Thank you, Mr. Chairman. To the judge, when you mentioned tolling, isn't a tolling process done by the sentencing judge?
It is, but in order for it to be done, the paperwork and all the information has to be back to the sentencing judge.
Well, when the toll order is given, when you sign the non-S, then the toll order is there until that person is picked up by the authorities, isn't it?
That's correct, but we're talking about transferring. So if you have a jurisdiction that's in North Georgia, the judge in South Georgia is not going to know that there's a violation until that information gets back to them.
Thank you.
So that would be the lag and the time that I'm referencing.
All right. Any further questions of the judge? Thank you, Judge.
Thank you.
Let's see. Yes, sir.
Mr. Chairman, I appreciate Representative Jackson's intent here, but I know there's a lot of issues with this, and at this time, if it's okay with the chairman, I'd make a motion to table this bill.
All right, we have a motion to table. Do we have a second? Second. We have a motion and a second to table. Any discussion? Any subsequent motions? If not, all in favor say aye.
Aye.
Opposed?
No.
Show of hands. All in favor say aye. 1, 2, 3, 4, 5, 6, 7. All right. Opposed? 2, 3, 4, 5. All right. This bill will be laid on the table. If I might make a recommendation, Mac, Representative Jackson, if you can work with, maybe call in community supervision, talk with them, talk with some of the judges, and if we can come to a resolution of some different wording on this, if you'll bring it back, then we'll move it forward, and then we can probably attach it to something. All right. Thank you, sir.
Thank you.
Let's see. And then last but not least, House Bill 541. Representative Mathiak.
Morning, Mr. Chairman and LEG Council and committee. I'm very thankful for you to have us here today to hear about domestic violence in Georgia. For the past 12 months, the Georgia Coalition Against Domestic Violence has worked diligently with LEG Council and Georgia Carry and some of the other players within the domestic violence arena, so to speak. I wanted to bring this forward as a federal version, but LEG Council has helped us with a different pathway for the state of Georgia. The bill before you, which I would like to make sure everybody's on the same page, is LC 297985 ERS. I'm assuming that everybody has that. This relates to offenders that have been convicted of domestic violence misdemeanors. I don't want to debate the merits of our legislation and the federal law. We've only got about 17 counties, give or take, that enforce that federal law because we don't have a state mechanism that will tackle that issue. Alabama, Tennessee, North and South Carolina, and Florida all have state versions of that federal law. We happen to be the outlier. That's why we're here today. I believe that we're all talking about the same thing, and I know that everyone here wants to solve this issue, especially in today's temperature. I look forward to working with everyone to solve this crisis. I saw the Georgia Carey email last night. Some of my buddies from Griffin made sure that I saw that over and over again, so I'm appreciative of that. And I want everybody to know that the federal version is where we're headed. Georgia Carey has stated that this bill, had it been represented as that mirroring the federal statute, that we probably would not have been here today. And I couldn't agree with them more and want to work towards that legislation. This is committed between past or present spouses, persons who are parents of the same child, parents and children, step-parents and stepchildren, foster parents, foster children, and other persons living or formerly living in a same household. The court shall inform the offender in writing about the prohibition of receiving, possessing, or transporting a firearm. And like I said, each one of those sections talk about assault, battery, simple battery, and pointing the gun. On page 4, no, excuse me, I've got the wrong page. On page 3, line 76, it says misdemeanor crime of family violence. That's where we define. And then it refers back to those 3 codes or those 3 sections that I just talked about. This is committed between a past or present spouse. Okay, that it goes back over. That's the portion that goes back over who may have been violated in a domestic violence situation: spouses, parents, children, stepchildren, foster children. or is involved in attempting the use of physical force or use or threatened with a firearm. Excuse me. The rest of the bill talks about being informed orally and written by the judges, giving you 24 hours to be able to surrender your firearms to it. We've got in here federally licensed firearm dealer. I would like to see us be able to put law enforcement, and I actually had somebody from home that works for the federal government that he even seen somewhere where you could relinquish your firearm to a clergy. We can talk about that as we go through this. Is there any questions if I can help you with anything? And I would like to remind you that this is a conviction of a misdemeanor family violence act. You have to be convicted, and I understand that that we don't want to take our guns away for no apparent reason. But if a person's being convicted of that misdemeanor, then I think that our families that have been violated need some support and need some assurance that they are going to be safe.
All right. Questions? Mr. Petrie.
Yes, thank you, Representative. As you know, I passed a gun bill earlier
Yes,
this
sir.
session that is targeted toward keeping guns out of the hands of violent people, felons.
Yes, sir.
And I'm all in on that. I have some very good friends whose daughter was murdered by her husband. So I'm also very sensitive to domestic violence. She actually wasn't shot, she was strangled to death. So there's many ways we, unfortunately, in this society abuse our spouses. But at any rate, so I'm all in on making sure we keep guns out of the hands of violent people. But my concern, and the concerns I'm getting from a lot of my constituents, are that this is a misdemeanor. So, and by the way, even if I think about women who want to protect themselves, so help me to understand something. If a husband and wife are arguing and fighting, pushing each other, happens all the time, and law enforcement's called, they both wind up with a misdemeanor conviction of family violence, both of them. They both then, and the woman, let's say in this instance as well, may lose her constitutional right to protect herself. So is that not an accurate portrayal of what could happen if we open this up? And I understand with the current federal statutes, but I'm just seeing this as of yesterday, and so help me to understand how we might not be harming some people by removing their ability to defend themselves from maybe domestic abusers.
Okay. Thank you. I appreciate that. I think that we have to think about, usually when law enforcement is called, this isn't the first time, and we'll use your example, that this husband and wife has had a problem. Would you agree?
I would agree.
I think, and as I read through some of these stories, I think that's what concerned me more than anything, Representative. If you are going to have that volatile of a situation between a husband and wife, what happens when it's a child that's involved? Especially if this is an ongoing situation, I'm not so sure either one of them should have a firearm. I think I could argue that. I think I could argue that.
All right. Appreciate your answer. Mr. Blanton.
I guess my concerns are along the same line as Representative Peters is that you've got a young couple, 22-ish, 23-ish. They get in an argument. One pushes or slaps the other, and they push this person off. They both actually assaulted each other. Is that correct?
Yes.
So at that point, both are subject to this law, and both would be subject to losing their right to bear arms. Is that correct?
Yes.
Oh.
If they are convicted. At the very beginning of the code, it says, relating to crimes and offenses so as to prohibit a person convicted of the misdemeanor crime of family violence.
Would you?
So,
I'm sorry.
go ahead. I'm sorry.
Would you agree that if I unsolicitedly touch my friend over here, even to just push him off, the fact that I touched him constitutes an assault if it's uninvited? Is that correct?
Can I refer to my attorneys that are with me? Mr. Chairman, I'm not an attorney, so I can't. As I'm reading through this, I understand what simple assault, simple battery, but what are the components of that and what would actually happen into a court of law? That, Mr. Chairman, can I ask for some help in that situation?
Representative, quite simply, to answer your question, you being accused of something is not the same as you being convicted. So there is a threshold in which a judge or a jury would have to make a determination that you're guilty.
Well, I all due respect, sir, I think I understand that. But my question is, because it's pretty simple. Assault is when you put your hands on someone.
If you're convicted.
If you're convicted. And so the burden of proof basically has to do with whether I touched them or didn't touch them. Would you agree?
Well, the burden will be on the conviction, though. If the judge and the jury sees that the evidence bears that out, then yes. But there is a judge and jury that would determine that.
Right. So regardless of the circumstances, if they touch each other, then that's pretty much a done deal, isn't it?
No, sir. They have to be convicted. There's lots of things that don't reach that threshold in a court of law, as you know.
All right. Thank you.
Yes, sir.
Thank you, Mr. Chairman. Thank you, Representative Mathiak, for being here. Question on line 17. It's not the first time this appears. It appears a few more times in the bill. But I wanted to just throw out something, kind of food for thought, and see if you might could give me some direction here. But starting after the second or formerly living in the same household, would that include, say, for instance, my roommate from University of Georgia, who I'm still super close with, friends with, we get together now? My reading is that would include that, correct? Because we lived together for 2 years.
Representative Cook, my name is Wendy Clifton, and my client in this matter is the Georgia Coalition Against Domestic Violence. This language actually comes from current law in the domestic violence code sections, in the family law, in the family violence code sections that are already in the law. And so this is not new concepts or
Right.
language. I think your reading of it is exactly right. There are circumstances where you have roommates where there are domestic violence situations, and that's current law already. All we did was pluck that language out of those other code sections and insert them here so that the family violence misdemeanor language would be present. Does that make sense?
Yes, it does. Thank you for that. And that's kind of where I'm going now with my question. So would this be an appropriate action for, again, let me carry on my example here. We still get together and watch Georgia football games all the time. And say, for instance, this doesn't happen with us, but say, for instance, that some, football game gets out of hand and, everybody's having a good time. Next thing you know, arguments start. And say it happened between me and my roommate who we lived together. I don't want to say how long ago it was now, but it was some time ago now. It was in the 2000s, but just barely. But say, for instance, he pushes me, I fall down the stairs, or vice versa. And we just get really mad at each other, decide, you know what, he treated me wrong, we're going to court, and he gets convicted. We hadn't lived together since 2003, but under this bill, he wouldn't be able to possess a gun anymore. He's got a wife and 2 kids, not be able to protect himself or his family. Am I incorrect in that example? I mean,
Is
it doesn't
there-
seem too outlandish either, to me. I mean, maybe I'm the only one, but.
Well, Representative Cook, if I may, that's why we're here. This bill literally we got last night at the behest of lead counsel saying that we had constitutional concerns and they wanted to fix some things. We're here to work with you to perfect this legislation. So if you have a recommendation that would meet those concerns, we'd be happy to work with you on it. There's a lot of things in this bill, guys, so that we don't get stuck on that and waste a lot of time that we need to work through because we have less than 24 hours to digest it. So just to give her a little bit of latitude, we'll work with you on that part of it. What we appreciate is your time and attention to this issue.
Sure, okay. Thank you. Thank you.
Thank you.
All right. Any other questions from any of the committee members? Who's number 10? Yes, sir. Chairman Jaspers.
Hey, thank you, Ms. Mathiak. I just got 2 or 3 questions that the chairman will allow. How long is the prohibition that's taking someone's weapon away?
It is my understanding that there are laws involved that you can go back and try to get your weapon back or your firearm back.
So this is a
through
permanent-
pardons and paroles.
So
So there are laws. I'm sorry, I didn't mean to.
As it's written, this prohibition is forever.
Point taken.
And so I guess I'm asking, it seems to me that what's going here is that we want to treat these simple assaults as felonies, as it regards to weapons. Is that not true?
I think that what happens is by the time the law is involved in a family violence situation, it's not the first phone call. And therein lies why this is coming together. I hear what you're saying. I do hear what you're saying. And maybe that's where further law needs to be more specific.
So it would be true that we're treating this as a felony, a simple assault as it relates to weapons.
I don't think so, but can you help me with that?
Representative Jaspers, thank you for your question. This is part of what I was saying to Representative Cook. We haven't had even a full day to digest what Lake Council put in the bill. So we appreciate Mr. Chairman putting us on agenda so we can have this conversation. We'll be happy to work with you to make sure it is not treated like a felony. The intent of this is to make sure that misdemeanors and felonies of convicted domestic abusers do not have the ability to harm further family members and or police officers. We'll work with you to accomplish that goal however is possible.
So, Mr. Chairman, this is directed to you. So this is a hearing that we're having?
This is hearing only.
Okay. And I guess also, Representative Mathiak, I guess it goes to counsel behind you, made the declaration or a statement that misdemeanors had judges and juries. But if I'm not mistaken, most misdemeanors are just by judge. Is that not? I don't know. I'm just asking from somebody that does know.
Thank you.
I'd just like to know that.
Okay.
We have a judge here, Mr. Chairman. DA, I'm sorry.
Will you allow DA to speak? Will that help?
We're going to allow everyone to speak if they wish, but time is getting short.
I understand that.
And one last question I have, Mr. Chairman, is on this, the original bill that was presented, was dropped, had who the offender had to give the weapon to. I see that's been changed greatly now. Is there any, can it go to anyone they choose? Is that the purpose or?
The conversation that I had with folks from home that are from Georgia Carey, they were concerned about specific people, especially, and if you read through the email, did you get the Georgia email too?
Only 600.
Okay, kind of figured that.
Thank you, Jerry.
If it was a antique gun, a muzzle loader, something that was special to their family, and I I understood where they were going to, that those weapons may, or those firearms may disappear. So I think that's why we had the federally licensed firearms dealer. Some people also wanted law enforcement, and like I said, somebody that works for the federal government even said clergy last night. Now, I don't know where he got that. I don't know whether that was in federal law. Julius, maybe you know that, but you've never heard it. Okay. But those are the things that, those are the nuances that probably need to be spelled out. I'd like to see law enforcement in there. However, I don't think that should be the end of that list.
Okay. Thank you, Mr. Chairman.
Thank you. Mr. Glenn.
Thank you, Mr. Chairman, and all due respect to my colleague, the Madam Representative, it's kind of hard to ride a horse that's not there, and that's what I see. I don't see the legislation that we need to discuss and that we need to move on. I think that at this juncture, my suggestion, Mr. Chairman, respectfully, would be that they have an opportunity to look at this legislation, to vet it themselves, to determine what the revision is going to look like, and then we discuss it, because right now we're discussing things that may or may not end up in this legislation. There may be, through conversations, that things change, maybe a new thoughts process. And so I just think that at this point, Mr. Chairman, all due respect, this is not time well spent, because we need to see what we're going to be discussing and what we're going to be potentially voting on.
Thank you. Any other committee members? Any committee members? If you might just step aside, let's see if anyone else has got something they'd like to add to this.
Okay. Thank you, Mr. Chairman.
Anyone wishes to be heard? Yes, ma'am. If you would, come up and identify yourself, please.
Thank you, Commissioner, for having this hearing today. My name is April Biagioni. I am a wife, a mother of 3 boys, a native Georgian residing in Decatur, Georgia, and I'm also a UGA graduate. But the point here today is just having this hearing means a lot to a lot of us today. I grew up with Governor Jill's daughter in North Georgia, and outdoor sporting was huge with our family. We're not asking to take away, you know, the shotgun from my sister who she uses for protection, or the rifle that my brother uses for game hunting. We are asking for common sense gun legislation here under the Capitol. Common sense tells us that we don't want the guns in the hands of our teenagers. We don't want them on college campuses, and we definitely don't want them in the hands of convicted domestic abusers. Guns and domestic violence are a deadly and all too common combination. Women in the U.S. are 16 times more likely to be killed with a gun than women in other high-income countries. Every year, women suffer from 5.3 million incidents of intimate partner violence. In an average month, 50 women are killed here in the United States at the hands of intimate partner violence, and many more are injured. Nearly 1 million women alive today have been shot or shot at by an intimate partner. Georgia goes against federal law. We've already talked about this. I think it's time for us to get on the right side of this issue. This legislation will save lives. Cities that restrict access to guns by people subject to domestic violence restraining orders see a 25% reduction in intimate partner homicides, gun homicides. This legislation does exactly what we need. It keeps guns out of the hands who are convicted of people being violent already. Giving the privilege of having a gun to a convicted domestic abuser only endangers the lives of their partners and their families. This is common sense gun legislation. We deserve the same protections as you do under this gold dome. Guns are not allowed here. Why? Because of common sense. Over 1,500 people rallied outside last week with Moms Demand Gun Action. And we will rally every day until you stop focusing on partisan rhetoric and start listening to us, your constituents. It's people like us who care deeply about the safety and protection of life, liberty, and the pursuit of happiness in our great state of Georgia. Thank you for having this hearing today.
Thank you. Anyone has a question for the lady? Petrie.
I'm first.
Oh, I'm sorry, Mr. Glenn.
Thank you, Mr. Chairman. I just want to bring some clarity. My question is not whether we support or not support this bill. I will tell you that I grew up in a home filled with domestic violence. A mother who was beaten on almost a daily basis just because she existed. So my issue is not with whether we should be protecting folks against domestic violence. My issue, for clarity, is that I don't have a bill in front of me that I can dissect and make a determination as to the legitimacy of that bill. And so I want to make that explicitly clear that it has nothing to do with the intent of the bill. It has to do with the makeup of the current version of the bill.
Thank you. Mr. Pitcher.
Thank you. I want to echo what my colleague just said, because as I mentioned earlier, I've personally seen some of this in my own community with dear friends, family violence that resulted in death, a lot of different ways to die, in this case strangulation. But we all here want to solve the problem, but we got to make sure that we don't create new problems when we do so. So I'm going to ask you a question. I'm going to ask you to get some data for us. If you look at cities like Chicago and other cities that actually ban guns, I would like you to tell me if they indeed have lower levels of domestic violence in those communities. So you don't have to do it today. If you have that answer, I'd love to hear it. If not, when you come back, if you could bring some real data to show that indeed, if there were no guns that existed in these communities, you'd have less domestic violence. That would be helpful to your cause. Thank you.
Welcome. Any further questions from the committee? Anyone else wishing? Yes, ma'am.
I agree with you. I agree with you. The reason we're here today is domestic violence, not to take the gun away. Because we all hunt, we all want protection. I understand that. The thing that I would like for us to hear is a lot of times these types of situations start out with pretty high consequences, like a felony, and they get pled down to a misdemeanor. And I think that's the reason I got involved in this bill, is because of that type of legislation, or not legislation, but that type of circumstance that happens in these situations. They get pled down to a misdemeanor. And again, it's a conviction in here. There is on line 70, it says felony means offense punishable by imprisonment for a term of 1 year. So the felony, I would like for us to hear that there's a difference between felony and misdemeanor. And that's, ladies and gentlemen, that's what I wanted you to hear today. And there may be other reasons that some of the other folks have this bill in mind.
Next.
Good morning. My name is Sherry Boston. I am the district attorney for the Stone Mountain Judicial Circuit, DeKalb County. I am here also representing the interests of the Prosecuting Attorneys Council of Georgia, which consists of all the district attorneys and solicitor generals in the state, and we are in support of this legislation. Let me start by saying I think I can answer some of the questions because I am an attorney, and as a prosecutor, I'm faced with prosecuting. Prior to being DA, I was the Solicitor General in DeKalb County for 6 years. So it was my mission on a daily basis to prosecute misdemeanor domestic violence cases, and now I prosecute felony domestic violence cases. Let me start by first saying I'd love to give you some data. The first data point is that access to a firearm where domestic violence is occurring increases the risk of homicide by 500%. It is a real issue when you're talking about homes where there is domestic violence. Furthermore, since November, in DeKalb alone, we have had 5 domestic violence-related homicides. In each of those cases, there was a previous domestic violence misdemeanor conviction. And in half of those cases, the murder was committed by firearm, including a young woman who had already gotten a conviction against her boyfriend for a misdemeanor. He showed up at her job outside of the post office, ambushed her in the parking lot, and shot and killed her. These are the types of cases that we're dealing with every day. So a few things I want to make clear, because there's been some examples up here about touching and what's assault and what's battery. First and foremost, this bill only addresses cases where there is a misdemeanor conviction of family violence battery. Now, we know there are situations of mutual combat. I've heard that when we talk about the husband and wife and two people being arrested. We call that in my world mutual combat. But we get those cases every day. And law enforcement has to make the best decision they can on the scene. But when it gets to my office as the prosecutor, we do further investigation and we determine what the charges are. It is a rare situation in the prosecution world where you will see us charging two people in the same situation from a mutual combat situation with family violence battery. Those cases simply don't end up, for the most part, with that type of resolution, because we recognize that the facts don't support that. So that's first and foremost. We also in DeKalb offer diversion programs for those types of situations where we don't think lethality is an issue. But where lethality is an issue, and where we do get a misdemeanor conviction for family violence battery, our concern is that those abusers will continue, perhaps, to stalk and abuse their victims. And the only thing we want to do with this bill, and the language in there about the relationships is the exact language that exists right now. And yes, I hope that you never get into a fight with your roommate from Georgia from many years ago. But that's an example where if a case like that came to my office, we wouldn't treat that as family violence because it doesn't have the signs of family violence. But if there were two roommates currently at University of Georgia that were engaged in conduct and current roommates, that absolutely may fall to the level of a domestic violence situation, and we have seen that. So having said that, I want the committee to understand why this bill is so important. And it really is to protect those persons that we know, if given access to firearms, will take those firearms and shoot and kill their victims. Now, yes, strangulation is a problem. That's why we have great strangulation bills that I came down here and lobbied for, to help us prosecute those cases. But to strangle somebody, you got to get a lot closer than a gun. And so we need to make sure that we continue to protect our victims from family violence, from domestic violence, and remember that the most deadliest call that a law enforcement officer faces on a daily basis is a domestic violence call. They don't know what they're walking into. And our domestic violence calls, our disturbance in a home calls, those are often and plenty across our jurisdiction. So I hope that we can continue to have this dialogue and get a bill that everyone can look at and see. But I want everyone here to understand why this bill is so important. And the only thing we're seeking to do is have the same protections that we already have on the federal level, and make sure that here in Georgia, that we as local prosecutors can protect our citizens. Thank you.
Thank you, Madam Prosecutor. If I might ask, how many prosecutors are there in the state?
There are 59 district attorneys that make up the circuits here. As far as the Solicitor Generals, that number is much bigger. I want to say 116. And again, our Executive Director, Pete Scandalakis, former DA in Coweta, could not be here this morning, and he asked me to let you all know that this legislation has the full support and weight of the DAs and the solicitors across the state of Georgia.
All right. Very good. Thank you so much. We have one question. Yes, sir.
DA Boston. First, I want to let the committee know that DA Boston is my DA. Thank you for being here today. And isn't it true that this isn't a novel idea, and in fact, my understanding is that about 29 states have similar statutes on their books. Is that correct?
That's absolutely correct.
And of those states, they include states like Alabama and Texas, and states that may have similar political profiles to Georgia. So this isn't like a liberal notion or anything like that. This is something that is supported by law enforcement, and just is something that I would say is kind of a common sense measure to do what you said at the beginning, which is to dramatically reduce the rates of violence where we know that the presence of a firearm has all too often led to fatalities.
Yes, Representative Holcomb, and I believe that Georgia may be the only state in the Southeast that does not have this type of legislation mirroring the federal statute.
Any other questions? Thank you, ma'am.
Thank you.
All right, we're getting awful short. We've got some folks that's been a little bit long-winded on this. How many folks have we got that wants to be heard? I see 3. I see 4. Can each of y'all speak in less than 2 minutes each? Well, I'd advise somebody to get on up out of the podium. This meeting will be over shortly. We're on the schedule to 12 o'clock.
Thank you, sir. My name is Jennifer Thomas. I'm the Executive Director for the Georgia Commission on Family Violence, and I appreciate your time and attention to this matter. I want to express the Commission's support of this bill and this concept of removing firearms from individuals that we know are dangerous in their homes. We appreciate the work of Representative Mathiak and the committee to find solutions for creating opportunities for safer homes in Georgia. I have with me today Jennifer Waindale. She's an investigator with the District Attorney's Office in DeKalb. She's a former probation officer for misdemeanor, and I think her experiences are going to help further emphasize why this legislation is needed here in our state.
Thank you. Good morning, and thank you for allowing me to be here today and share my experience with you as you weigh your decisions on the future versions of this bill. It's been my honor to serve the citizens of DeKalb County as a peace officer for 13 years. I'm currently an investigator, like you heard, in the DeKalb County DA's office, but prior to that, I was a probation officer and final supervisor with the DeKalb County State Court Probation Department. And I was in charge of their specialized domestic violence unit there, which we saw or monitored almost 1,000 cases per year between 3 officers and a supervisor. And I have the unique perspective of seeing both sides of these cases that come through our criminal justice system in the pre- and post-conviction phase. And what I can tell you and what I learned in the trenches of supervising a domestic violence unit is there is a giant gap between federal and state law when it comes to this. And what you've already kind of heard and referenced, and I won't bore you with, is in 1996, the United States Congress amended the Gun Control Act. So some of the language that you're seeing has already been on the books for 22 years, and Georgia's lagging behind in catching up with that. What's been occurring throughout the state is that convicted offenders still have access to these firearms and commit a host of additional crimes post-conviction. Some of these may be new intimate partner crimes, but what I saw were many additional dangers to law enforcement and the general public. So I'd have folks that I'd monitor that would go out and commit new armed robberies, new aggravated assaults, aggravated assault or attempted homicide on a police officer, or homicides on other members of the public. It's not just a risk to intimate partners. It's a risk to me as a law enforcement officer, and it's a risk to your constituents as the general public. I'd receive also emails and phone calls weekly asking me or informing me about prohibited persons attempting to purchase a firearm, a new one. These were new attempts to purchase, or they were training the firearms that they already had because there isn't a mechanism in the state books to say you can't have that gun. And they're continuing to be a threat to public safety. And there's no uniform mechanism or recourse to hold that offender accountable for possessing a weapon that they shouldn't even have. And because of that giant gap in Georgia, a gap between the federal and state law. So, for example, me monitoring the case as the probation officer, if I would have a new offender that would go out and commit those offenses that I just told you about, and they'd be caught with a firearm, local law enforcement, sometimes local judges, wouldn't know what to do with that. They wouldn't know how to address that because they feel that there's not a mechanism in place on the state law perspective to tell them what they can do and what they can't do. And they want to hold these offenders accountable. Me as the probation officer, me as a police officer want to hold these folks accountable, and we want to keep people safe. And I can personally say, after conducting many in-person workshops nationally and throughout the state of Georgia and online webinar trainings, there are many law enforcement agencies, judicial agencies in Georgia who are very interested in this public safety concern, and they need that clearer perspective and guidance from you, the legislators, to assist them in keeping their constituents safe. It's up to you to give me and my brother and sister police officers the tools needed to charge these offenders, hold them accountable, and save many lives in the process. It's no different to me as a peace officer in my mindset as when I catch a convicted felon with a firearm. There's a charge out there for me as possession of a firearm by a convicted felon. It would be the same mechanism to enforce it, and it would be the same mechanism in place to figure out what to do with those firearms. So that's about as quick as I could do your version, Mr. Chairman.
Thank you. Ma'am, you got about 1 minute.
I'll do my best.
I'm so sorry.
I'll go ahead and thank you all from here. My name is Paige. I'm a lifelong Georgian, a friend of multiple domestic violence survivors, and a sister to 3 law enforcement officers. I'm here today to urge this committee to support HB 451, which would help keep guns out of the hands of domestic abusers by bringing Georgia in line with federal law. This makes sense, as we know that in America, women are 16 times more likely to be shot and killed by an intimate partner than women in other countries. We also know the presence of a gun in a domestic violence situation makes it 5 times more likely that a woman will be shot and killed. We need to do everything in our power to keep guns out of the hands of domestic abusers. But Georgia law has a loophole that allows domestic abusers to have easy access to guns. This endangers Georgians, and it leaves Georgia law enforcement, the officers on the ground in our communities, and the ones who are responding to domestic violence calls, powerless to enforce the current prohibition. 25% of law enforcement officers killed in the line of duty are killed on domestic violence calls. Instead, Georgia is at the mercy of federal law enforcement, their priorities and their response, or they have to hope that there are other legal reasons to make sure a domestic abuser does not have a gun. That should not be the case. We must give our law enforcement the tools they need to prevent domestic violence in our communities, and it is clear we need to do more. In 2016, there were 121 recorded domestic violence-related deaths in Georgia, 71% of which were committed with a firearm. One analysis showed that Georgia has the 8th highest rate of intimate partner gun homicide in the nation. This bill would do 2 things. First, it would specify that people convicted of misdemeanor domestic violence crimes committed against their intimate partners or family members would be prohibited by law from buying or having a gun. It would also create an enforcement mechanism requiring a person to relinquish guns they already have only when they are convicted and become prohibited by law from having them. Georgia is lagging behind its peers in terms of this life-saving legislation. Since 2015, Alabama, South Carolina, Tennessee have all acted to pass legislation to keep guns out of the hands of domestic abusers. Georgia needs to follow suit. I urge you to adopt this important legislation, and I thank you for your time.
Thank you, ma'am. All right, ladies and gentlemen, we've got Ms. Brown that would like to, she's got about 10 seconds.
Oh, okay, I'll play by the rules. I'm Deborah Brown. I'm a voter and I'm a mother. I'm not representing an organization. I'm just representing your constituents. And I want to say, first off, that it really offends me when I hear you guys minimize what violence does to a family. And I'm not going to go too far into that, but I think that this law will save many lives. And I think that we've been giving a pass to people that have hurt their loved ones in a way that we should never, ever do. And we know that once they become convicted of a misdemeanor, they definitely deserve it. You know, our justice system makes some mistakes, but this is one area that mistakes are not being made. And I'd also like to just say, as a survivor of domestic violence, I was really, I lived in California 20 years ago when this happened. I was very grateful for the state laws there that kept me safe, kept my children safe. Yes, we still had to go to a secret shelter because law doesn't happen, you know, right when they're arrested. But ultimately, we're alive, my children are alive, and that wouldn't have been the case if it wasn't for the law. So I hope that Georgia catches up with the federal government and the other southeastern states that I hear about. This seems like a very simple fix to get in line and save lives. That's all I want to say.
Thank you, ma'am. We appreciate it. Committee members, I want to extend my appreciation for y'all to be here this morning. On this particular issue, the reason that we called this bill up for a hearing was so that the committee could see exactly the difficulty in how to deal with this issue. There are some of us that tend to believe that Second Amendment rights, do they need to be held in jeopardy based on misdemeanors? That's never been the standard except in this particular case. Domestic violence is a very serious situation, and that's the reason I want this committee members, all these committee members, to know what some of these arguments are for and against this type of legislation. That being said, I want to thank everybody for being in attendance today, and this meeting is now adjourned.
Thank you, Mr. Chairman and the committee. I appreciate you all.